I have already messed it up once today with another attorney. So we have a cross appeal. Have you all had an opportunity to discuss how you would like to present this? If not, I'll tell you what my leaning is. Go ahead. Ms. Ryder, you're nodding. Go ahead.
Oh, good morning. Yes, I represent Brian Reynolds and the Reynolds defendants. And just briefly, as the court knows, the parties have stipulated that if the judgment against State Farm is affirmed, or I'm sorry, the judgment in favor of State Farm is affirmed, then the judgment in favor of the Reynolds defendants should also be affirmed. And we therefore joined in State Farm's briefing. And other than being here, being available for whatever specific questions the court may have, we are ceding our oral argument time to counsel for State Farm, Mr. Levisky.
Very good. And then Ms. Gunn and Mr. Levisky, do you all agree that we will go ahead with the standard 20 minutes and you, Ms. Gunn, can address the cross appeal in your initial argument, or do you want to do that in rebuttal? And then do you want, I guess, Mr. Levisky, do you then want rebuttal as well?
Your Honor, I'm fine with whichever the court prefers.
And Mr. Levisky, any thoughts?
I think to be easiest, I think my argument will focus primarily on the main appeal, and we'll address it, briefly as needed. So what would make sense to me is Ms. Gunn goes for her 20 minutes less rebuttal. I'll do 20 at once, and she can have the rebuttal rather than try to save Sir rebuttal for the cross appeal and that sort of thing.
If you decide you wish to reserve a couple minutes for rebuttal on the cross appeal, just let me know. Otherwise, we will proceed in that way. So Ms. Gunn, the floor is yours.
Thank you, Your Honor. May it please the court. Good morning. My name is Tracy Gunn. I represent the appellant cross appellee, in this case, Don Carapella. I would like to reserve 5 minutes for that rebuttal, please, Your Honor.
Very good.
The court has already heard that this proceeding involves 3 related appeals. We have our main appeal, which is the summary judgment in favor of State Farm. We have the consolidated appeal, which is the summary judgment in favor of defense attorneys, which will follow whatever the court's ruling is here on the State Farm issue. And then we have State Farm's cross appeal, which is a collateral attack on the underlying judgment against the insured. So turning first to the main appeal of our appeal of the summary judgment in favor of State Farm, the trial court found 3 different reasons that State Farm had no duty as a matter of law in this case. The first relates to the nature of the proposal. The question was whether the nature of the proposal entitled State Farm to a judgment as a matter of law. And it's our position that the trial court improperly weighed disputed issues of fact when determining that the proposal was changed to require a consent judgment, that the trial court erred in treating the stay proposal as a Cunningham agreement, and that under either scenario, the trial court erred in finding no duty as a matter of law. So turning to the facts that would support a jury finding that the stay proposal was not amended to require a consent judgment, our evidence is very different from their evidence. Our evidence is the letters which were written by the parties at the time of the settlement discussions. State Farm's evidence is affidavits that were prepared by their lawyer and the defense lawyer years later. It is undisputed that the original proposal was just for a stay and was not for a consent judgment.
Can I just ask one question real fast so I understand your argument? Was there coverage or no coverage, or does that make a difference to your argument on appeal?
There was no coverage, and our position is that does not make a difference. That is the second grounds for the ruling of no duty as a matter of law, Your Honor. The trial court did accept State Farm's argument that the findings of no coverage in the declaratory actions erased whatever bad faith might have happened during the conduct of the defense prior to that time. Of course, it's our position that the State Farm was in fact defending the insured, that we know that defending the insured creates a fiduciary duty under Florida law, and that the later determinations of no coverage cannot go back in time and erase whatever breach of that duty occurred during the time of the defense.
So that's a corollary of the thesis that the duty to defend is broader than the issue of coverage.
It is, Your Honor, yes. And I'm happy to turn to that point first. The trial court did find, as a matter of law, there's no bad faith if there's no coverage. And the crux here is the duty that existed during the time that State Farm is controlling the defense. It's undisputed under Florida law that that is a fiduciary duty. And so the question becomes, once the insurance, and it's undisputed factually in this case that State Farm did in fact defend, did control the defense, did exclusively control settlement, and did reject the settlement opportunity when the insured and her appointed defense counsel wanted to accept it. So then the issue becomes, once the insurance company undertakes to defend and exercises this control, do they have duties that flow from that defense and control? And our position is yes, under Florida law, they do.
Ms. Gunn, one of the settlement proposals was, can we agree to stay or abate the case, correct?
Yes, Your Honor, that was the original proposal. This is what we're calling this.
Did anything preclude the appellant from filing a motion to stay or abate with the trial court and asking the court to make that determination?
No, Your Honor, I don't think it would have. I think that the parties were discussing it.
They were discussing it, but if the appellant felt aggrieved by a failure by the parties to agree to a stay,
right,
the appellant could have asked the trial court, put this on hold until we get the declaratory judgment action resolved. So if that's true, how can there be an obligation on an opposing party to agree to a stay when it seems like they don't have to, and your client wouldn't be prejudiced, at least to the point of asking the court to enter a stay?
And Your Honor, I think that raises exactly what the issue is in this case. State Farm didn't have any problem with agreeing to the stay. State Farm said, and we know from their rejection letter exactly what State Farm's problem was at page 3910 of the record, that we would agree to shelve the tort case and determine coverage first, because as we know from the Canal case and the Higgins case, it makes sense in most cases to go ahead and figure out if there's any coverage there before we spend time and money litigating the tort case. So that's the state proposal. The reason that State Farm wasn't willing to agree to that, they did file the coverage cases. They were seeking to have this declaratory judgments determined. The key to this case is that the reason State Farm was not going to agree to it was because they wanted a release of the bad faith case. What State Farm wanted was this deal where if there's coverage, if there's no coverage, everybody's out. That was agreed. If there is coverage, our insured gets out, we pay the policy limits, our insured gets out. That part was agreed. What State Farm also wanted, which is a breach of the fiduciary duty, was to protect themselves.
Well, but at that point in time, when the settlement discussions were underway, is there anything in the record suggesting that there would be a bad faith claim up to that point?
That's kind of the Schrodinger's bad faith claim, Your Honor, is the way that I'm thinking of it, which is it kind of depended on the outcome of the coverage cases.
But what I'm thinking about is the question that you're positing is that the bad faith is as a result of a failure to agree to a stay or to counter the proposal to stay with another offer, which would be, well, okay, we don't think there's a bad faith claim here. Let's get that off the table because we're going to agree to pay the policy limits if there is coverage.
Right. And then at that point that's the key question in this case. Is it okay as a matter of law that the insurance company was willing to stay the tort case and proceed to the coverage determinations, was willing to say, okay, we'll pay the policy limits if we lose coverage to get the insured out, but only if we also get a release of whatever bad faith case may have accrued up until this time. And whether there was one or not depended on, again, whether there was coverage. That's the law for it case. So if
isn't a bad faith case typically there is a belief in coverage, there's a failure to offer the policy limits or some reasonable amount, then the case goes to trial and there's an excess verdict. And then the argument is, well, they were in bad faith by not offering the policy limits. But does our record reflect that there was a refute? I mean, there wasn't an offer of policy limits because they were trying to determine, or everybody was concerned, is there coverage or not? So that's where I'm having a little bit of trouble following the argument that by saying, look, we're willing to stay the case if you give us an acknowledgement that there's no bad faith or give us a release from bad faith. Your client says, no, we're not willing to do that, but your client could have sought a stay in the case anyway from the trial court.
Could have sought the stay, yes, Your Honor, that's true. The stay, of course, at that point would have been proper but discretionary. So we were seeking an agreement to it. And the key to the agreement, the key to the proposal was not just let's stay it, it was let's stay it and win or lose, the insured is protected. The insured is protected if there's no coverage because we're going to just let everybody out because it's not worth following up on this. The insured is protected if there is coverage because we'll accept the policy limits to let your insured out. So that's the key. The key is, what is the duty? The duty is to protect the insured. The duty is not to protect the insurance company. At the time you're defending, you can't hold protecting the insured hostage to get your own bad faith release. State Farm is not even arguing that you can't. So they're saying we didn't do that. And it's our position that the documents showed that you did. And the issue of whether there can be a duty of good faith where there's no coverage, our position is it's answered by the Game case, which says, the court below erred in granting summary judgment based on its premise that since the company owed no duty, it was free to act in bad faith toward the insured. So, our argument is that it's essential and fundamental that the insurance company cannot put their interests ahead of the interests of the insured. That is the Boston Old Colony case, the LaForest case, the Burgess case, the Harvey case. And to the extent that this record reflects, and we believe that there's at least a jury question that it does, that the reason that State Farm did not agree to this proposal, which was not merely stay or not stay, but protect the insured either way, regardless of the outcome of the coverage case, your insured is protected. The reason State Farm did not agree to that is because they wanted out too. Whether there was or wasn't a valid bad faith case at that time is really, frankly, not relevant, Your Honor. What's relevant is that State Farm was saying, we'll protect the insured. We agree to all of this, but only if we get protected too. And that is a breach of the duty of good faith under Florida law. What the trial court held was, first, that the stay proposal was not just a stay proposal, that it had been amended to require a consent judgment. I believe we've pointed to the facts in the record that show that the trial court erred in determining that disputed fact issue contrary to the light most favorable to the non-moving party. But, and then why did the trial court not look at these letters the same way that we're looking at these letters? It's because the trial court said, you have to have filed an affidavit. And so it's our position that the trial court erred in requiring the non-moving party to rely on an affidavit instead of the contemporaneous letters. On the issue of the duty, and the duty as a matter of law, I do want to address the supplemental authority case, which State Farm filed, because it says exactly what we argued in our brief, which is the ruling below was you required a consent judgment. Even if you didn't require a consent judgment, you required a Cunningham agreement. And under Kropalak, if there's a consent judgment or a Cunningham agreement, that can't sustain a claim for bad faith. Our argument was we didn't require a consent judgment. The state proposal is not a Cunningham agreement, but regardless, saying consent judgment or saying Cunningham agreement does not operate as some magic spell that erases whatever bad faith has happened otherwise. And that's exactly what this court held in the Marcuson case. The holding in Kropalak is not so expansive as to eliminate other theories of bad faith. How State Farm handled the claimant's claim against the insured. And that's exactly our theory of bad faith here, Your Honor. Looking at whether the trial court erred in how it viewed the proposal, the trial court did err in finding not only that the consent judgment was required in the face of these contemporaneous letters stating, one, this is an alternative option, and two, hey, what about the stay? What about the stay? Without even mentioning consent judgment. And then
Ms. Gunn,
second, yes,
let's say you're right. And it's a question of fact. What did this offer mean? And arguably State Farm and Reynolds misunderstood what the
Right.
offer was saying. So what you are doing is arguably, elevating what is arguably at worst maybe malpractice. And I'm not saying that exists, but you're elevating that to an insurance claim of bad faith. And so I'm not sure how you're making that leap.
well, Your Honor, the duty that State Farm had while it's defending its insured was to protect the insured. And we can say over here, there's this confusion about whether there was or wasn't a consent judgment required. We know from the Marcuson case that doesn't eliminate all other ways in which the insurance company breached its duty. And so our theory here is that the insurance company breached its duty by saying, we'll agree to this stay proposal, but only if we also get a release. So whether rejecting a misunderstanding about whether the consent judgment was required also should have been immediately cleared up upon the rejection. Now remember that no communication with the plaintiffs ever said, we think a consent judgment is required. State Farm's rejection letter said, you proposed the stay issue. We thought we were going to get out of our bad faith case. We're not, so we reject. No one mentioned a consent judgment as being the problem. In response, immediate response to the rejection letter, the two lawyers for the plaintiffs wrote back and said, all you had to do was agree to a stay. Now, they didn't say you didn't have to agree to the consent judgment because no one said, we think that you had to agree to the consent judgment. So it's our position that it's really not whether there was or wasn't a consent judgment required. We're not relying on the mistake about that so much as we're relying on the fact that State Farm elevated its interest ahead of the insureds.
Ms. Gunn, you're at the 5-minute
I know, I'm
mark.
sorry that my timer was not silenced, but yes, I will rely on the briefs for the remainder of the points on the main appeal. And I think I'll reserve, since counsel indicated maybe not too much focus on the cross appeal, I'll reserve that for my rebuttal time, or if the court has any questions about it, I'll reserve the rest of the time. Thank you.
Very good. Thank you very much. Mr. Levitsky. You're still on mute, Mr. Levitsky.
Thank you. Good afternoon, Your Honors. My name is Matt Levitsky. I represent the State Farm entities. Christina Game murdered one of her children and attempted to murder the other. She was convicted of murder and sentenced to prison for her crimes. The Ratels sued Miss Game and obtained a $500 million judgment. The Ratels then forced Miss Game into an involuntary bankruptcy, and the lawyer who represented the Ratels in the underlying case now represent the bankruptcy trustee. And Carapella, as the bankruptcy trustee, sues State Farm, alleging that State Farm breached a duty to Game to protect her from the financial consequences of her crimes, even though the trial courts have declared and Carapella has admitted there is no coverage under the State Farm policies for these acts. And Judge Valenti, that includes a duty to defend. The declarations is there's no duty to defend or indemnify under these policies. The trial court's order was correct, and this court should affirm for 3 separate and independent reasons. The first one is that State Farm had no duty to enter into the consent judgment proposed by attorney Lee Gunn on behalf of the Ratels. This court's recent opinion in Marcuson versus State Farm, issued on September 15th of this year, answers that question. Ms. Gunn said during her argument that her position was in the brief was consistent with Marcuson, but it wasn't. She argued that Kropalak, the decision that this court adopted in Marcuson, was wrongly decided. That was the argument, and that issue has been rejected. Second, there can be no cause of action for bad faith under Florida law without a covered loss. And in this case, there are judgments declaring that State Farm has no coverage under the policies, both defense and indemnity. Those judgments have been final for many, many, many years. And there are admissions in the record by Carapella that the State Farm policies provide no coverage to game. Third, Florida public policy prohibits indemnity through this twisted bad faith lawsuit for the crimes of Miss Game. To the first issue, that there is no duty to enter into a consent judgment. I want to, before I get to sort of the meat of my argument, I want to clear up a couple things. The record does not establish or support that State Farm's concern was releasing any potential bad faith claim. Ms. Gunn argued that the proposal was to protect the insureds. If there was coverage, there would be acceptance of the limits, and if there was no coverage, that they would dismiss the cases. That is the agreement that Attorney Kiernan wrote to Attorney Gunn that they would accept. What it is, and that argument really makes no sense under Florida law, because if there is a release of the insured under Florida law as a matter of law, there can never be a bad faith lawsuit. The Cope case out of the Florida Supreme Court says that, because absent that excess judgment, the insured has no liability. But it's not just law that says it. It's Carapella's brief. On page 17 of the reply brief, it says a release of the insured and an agreement to settle the entire case, all or nothing for the policy limits, is by definition a waiver of the bad faith claim. That's right. If there is a release of the insured, there can never be a bad faith case. And to the extent Carapella faults State Farm for attempting to settle the claim within the limits and offering its limits to for a release of Miss Game, that's not evidence of bad faith. That is quintessential evidence of good faith. Now I want to go through this consent judgment issue and this proposal. The duty of good faith generally requires insurers to settle where a reasonable insurer would do so up to the policy limits. The settlement agreements that courts see in all the bad faith jurisprudence is about paying money. The duty is not as broad as Carapella argues and asks this court to adopt, that requires insurers to do all manner of things that a claimant may demand. And I think this court's opinion in Markison articulates this principle extremely well. This court said, the obligation to negotiate and settle claims on behalf of its insured is defined by and bounded within the insurance contract itself. So that's where you look at what is the duty. It's what the contract says. In Kropelak versus 21st Century, the 11th Circuit Court of Appeals held that an insurer owes no duty to enter into a Cunningham agreement, and also owes no duty to its insurer to enter into consent judgment in excess of the policy limits. In Markison, this court adopted the Kropelak decision. So that is clearly the law of Florida and the law of this district. And faced with Kropelak, which I may add involved also Mr. Gunn, and the letters that were written in this case were written before the Kropelak opinion was issued. Carapella argues ways to try to get around Kropelak and now this court's opinion in Markison. Her contentions are belied by the evidence and immaterial in any event, and I want to go through the evidence. So what we have first is in December of 2010, there's a general discussion between attorney Gene Odom, who represented the Rattells, and attorney Brian Reynolds, who represented Miss Game, and there was a discussion about a potential stay. Attorney Reynolds responded with his understanding of the proposal. That is the only record evidence that Carapella points to of State Farm seeking to extinguish some bad faith claim, and that was not an offer or proposal by State Farm. It was a letter by Miss Game's attorney, who Carapella stands in the shoes of, memorializing his understanding of what attorney Odom had just said. Attorney Odom wrote back and said that attorney Reynolds' understanding was totally incorrect and that he would not agree to any, quote, mutual settlement agreement. This all picked back up in March of 2011, and attorney Odom proposed an agreement that if there was coverage, State Farm would pay its limits and Miss Game would be released. If there was no coverage, they would dismiss the case because, as Ms. Gunn articulated, there'd be no assets to go after. The record summary judgment evidence that the trial court had showed that the parties were nearing resolution on that basis, that State Farm was trying to settle on those terms. And that's the affidavit of Attorney Kiernan at record at page 3203. And it's at this point that Attorney Gunn became involved. And there was a call, and there was 3 people on that call: Attorney Kiernan, Attorney Reynolds, and Attorney Gunn. Attorney Reynolds and Attorney Kiernan have filed affidavits consistent with one another, filed well after one another in time, explaining exactly what happened. And that is that Attorney Gunn radically changed. That's the words used in their affidavits, and also the words used in the contemporaneous letter from Attorney Kiernan to Attorney Gunn around July of that year, that he radically changed the proposal to add as a term that State Farm agreed to a consent judgment, and then that the Rattels or Game would look solely to State Farm to pay that. So two attorneys filed an affidavit. The only person on that call who did not file an affidavit as to what happened is Mr. Gunn. Attorney Kiernan went further and said, I've read the Krokolak decision, and the proposal by Attorney Gunn on that call was the exact same as in, or materially the same as in Krokolak. So you have, on the one hand, the overwhelming evidence of the witnesses, Attorney Kiernan and Attorney Reynolds. You also have a letter after from Attorney Kiernan to Attorney Gunn saying, we agree to the proposal by Attorney Gunn, but we cannot agree as radically changed by you, Mr. Gunn. That's the evidence. And leaving or looking at all of that evidence, Carapella's position relies almost entirely on an April 13th, 2011 letter from Attorney Gunn to Attorney Kiernan that references not 2 proposals, a singular conceptual proposal. That's the word that's used, conceptual proposal, and it includes specifically a consent judgment, and it says that Mr. Gunn will circle back with the parties once he has a number to propose. Their position is based almost entirely on the word "in addition" on the second page, which they say, well, it must mean there was 2 proposals. No, it means a second element of the same proposal. But importantly here, there is no question of fact, because Florida has adopted the federal summary judgment standard, and we're beyond the scintilla and, can you glean some inference to avoid summary judgment? Those days are gone. And the correct test is whether the evidence is such that a reasonable jury could return a verdict for the non-moving party when opposing parties tell 2 different stories, one of which is blatantly contradicted by the record so that no reasonable jury could believe it. A court should not adopt that version of the facts for purposes of ruling on summary judgment. When you look at what the trial court had, an affidavit from Attorney Kiernan, an affidavit from Attorney Reynolds, letters from Attorney Kiernan saying, we would accept what was proposed by Attorney Odom, but you radically changed it. The April 13th letter of 2011 from Attorney Gunn representing a consent judgment. No reasonable jury could look at that evidence and say, no, we think that these lawyers were lying and that didn't happen. And so the trial court was correct in applying the federal summary judgment standard in determining that a consent judgment was a element of the proposal, and that being the case, there was no duty to enter into it. Regardless, even if the court credited the argument of counsel and the unsworn allegations of the complaint, neither of which are summary judgment evidence, and the trial court was correct not to credit those, there's still no duty. The Marcuson decision and the Krokolak decision build off the rule that there's no duty to enter into a Cunningham agreement. Cunningham agreement does not involve a consent judgment. It involves only the order of trials. In Cunningham, you try the bad faith case first. If there's no bad faith, the claimant will accept the policy limits in exchange for a release. If there is bad faith, then you go back and try the tort case and those liquidate the damages. This opinion, this proposal, even as set out in the unsworn argument of counsel and the unsworn allegations in the complaint, which again were not summary judgment evidence, is a riff on that, an order of trials. And the trial court was correct to find that there was no duty to enter into such a proposal. And again, this court in Marcuson said the obligation to negotiate and settle claims on behalf of its insured is defined by and bounded within the insurance contract itself. Carapella put forth no evidence in the trial court or argument, and nothing in the brief that the State Farm policies required State Farm to agree to any iteration of the proposal, even the one set out in the complaint, but not supported with summary judgment evidence. So the argument of a question of fact, I don't think the evidence supports that there's a question of fact, and I think the trial court was correct. But regardless, under any iteration, there was no duty to enter into it. Second point, there is no, Florida law does not recognize a cause of action for bad faith absent a covered loss. And we cite, there's many cases that say that, but one we cite is Maryland Casualty Company versus Alicia Diagnostic from the 5th District. If there is no insurance coverage, nor any loss or injury for which the insurer is obligated to indemnify, the insurer cannot have acted in bad faith in refusing to settle the claim. It's as black letter law as you get in the law. There is trial court declarations that there is no coverage. There are admissions in the record from Carapella that on 4307 of the record that there is no coverage. So there is no dispute that there is no coverage, no duty to defend, no duty to indemnify, no duty to anything under this policy. In Best versus Travelers, the Supreme Court, I think, articulated the law in a way that's consistent with the 5th District and said that in order to state a cause of action for bad faith, the insured had alleged that there's been a determination of the extent of damages covered by the underlying insurance contract. Covered. The key to all this is coverage. Carapella argues, well, these are first-party cases. They don't apply in third-party. This rule has been applied in numerous third-party cases. We've cited several in our brief, one of which is Helt versus Liberty by Judge Scriven out of the Middle District, where she applied Alicia, the Maryland Casualty Company. We also cite the General Star Indemnity versus Anheuser-Busch, which is out of the 5th District, where the 5th District said for both first-party and third-party bad faith claims against insurers, recent case laws clarified the point that coverage and liability issues must be determined before a bad faith case can be prosecuted. So that law is applicable both to third-party and first-party claims. Carapella argues that there can be bad faith without coverage, citing to a case from the former 5th Circuit before the 11th Circuit existed from 1970 and a discovery order from the 1st District. Those cases do not conflict with what has been the very well understood law in Florida of no bad faith without coverage, because in each of those cases there was coverage. In Ging, there was bodily injury coverage, and the argument was the insurer acted in bad faith in failing to settle the bodily injury claim, and that exposed me to punitives that would otherwise be not covered. But the duty to settle was there was a covered bodily injury claim. Oser and Calhoun being an unpublished Middle District decision, in those cases, which both, or Calhoun was in favor of the insurer, there was property damage liability coverage, and the argument was the insurer had an opportunity to settle all claims for the covered claim and had a duty to do so, failed to do so, and that exposed us to otherwise uncovered claims. So there was coverage in all of those cases, and that distinction was recognized by the Northern District in QBE versus Scrap Inc. in 2018, where the court specifically in rejecting this type of argument and the reliance on the Oser case, which is the discovery order from the 1st District, is recognized that coverage under the policy for property damage was already established. So there was coverage in those cases. I think a primary point that needs to be made in all of this is there is no Florida case in the decades of Florida jurisprudence that has recognized a viable bad faith case where there was no coverage at all. Bad faith has been going on for many decades. There's not one case. Carapella asked this court to be the first case to recognize a viable bad faith case where there was no coverage at all. That would be hugely upsetting to Florida bad faith law. Our final argument is that public policy prohibits indemnifying Game for her crimes. The judgment against Ms. Game for the $500 million is for obviously atrocious acts. Florida law prohibits, Florida public policy prohibits an insured from being indemnified for intentional criminal acts. So if Ms. Game had gone to her State Farm broker and said, I'd like to buy a policy, and paid a premium for something that would have covered these acts for any amount, but the $500 million judgment, had purchased the policy and State Farm accepted a premium, that policy would be void against public policy, because you cannot buy a policy that covers those types of acts. defies logic to allow bad faith jurisprudence to be twisted in this manner to essentially create indemnity so that the judgment against Game for her acts would be indemnified by State Farm, where had she even purchased a policy and paid a premium for it, this court and every other court would have said, you can't do that. It's void against public policy. There's other arguments in our brief. We have a cross appeal. I want to just touch on one thing very briefly on that if we get there. The trial court denied our motion to vacate the judgment entirely because for lack of standing, and our argument was there was no standing because Attorney Cope, who represented the Rattells at the time, filed a motion for leave to amend the complaint, had it granted, which mooted a potentially meritorious motion to dismiss, was given 20 days to amend, did not amend for 1,351 days, which generally would trigger Cazell concerns, filed a Fifth Amendment complaint without leave of court. A new judge was appointed, Judge Nielsen, to try the case, didn't alert him that had happened, got a default against Ms. Game, and then went to try the case, the whole time not alerting State Farm that this was happening. And our position is that judgment was void. We attempted to intervene as we were entitled to do under Florida law in the underlying case, but Carapella used the automatic bankruptcy stay to prevent us from doing that. So we went to do it in the bad faith case to collaterally attack the judgment, and we were told we lacked standing, and that was erroneous. Obviously, the general rule of standing is there has to be a direct and articulable interest in the controversy. That judgment forms the basis of this lawsuit, and there are two cases where courts have found insurers have standing to challenge judgments against their insureds where that judgment forms the basis of a bad faith lawsuit. That's Great American versus Beavis out of this court, and U.S. Fire versus Ted Satter Enterprises by the 4th District. And so for the remainder of the arguments on the cross appeal, we'll rely on our brief, but the point that the trial court denied our motion was on standing, and for those reasons, it's erroneous. I certainly am, I believe I have a minute left, so if there's any questions, I'm happy to answer them. Otherwise, I'll end my argument.
Very good. I don't see any questions. So Ms. Gunn, you have your 5 minutes for rebuttal.
Thank you, Your Honor. Turning first to the issue of whether State Farm wanted a release of the bad faith case, at page 3899 of the record, Mr. Reynolds describes what he believed to be the proposal, an agreement that no extra contractual damages will be pursued. And then the letter from Mr. Kiernan rejecting the state proposal at page 3910 of the record references Mr. Reynolds' understanding and says, the scenario was that the coverage action would determine this entire case on an all or nothing basis. If State Farm lost the coverage action, State Farm would pay their limits. It is our position that there's record evidence that, number one, would support a finding that the consent judgment was not required, and number two, would support a finding that State Farm was seeking a release of the bad faith case. Does that matter if there's a later finding of no coverage? Our position again is yes, it does, not because of a failure to pay, not because of a failure to the fact that there was coverage or not coverage during the time. It's because of the control of the defense. And this is not going to be the first case where a court holds that controlling the defense creates a duty. That duty has been recognized since Boston Old Colony was reconfirmed as recently as the Harvey case, which did not involve a failure to pay, that involved a non-monetary term. And what the courts have consistently held is that the reason for this fiduciary duty in a third-party case is because the insured is giving over control of defense and control of settlement. State Farm does not argue and cannot dispute that they were in fact defending, they were in fact controlling the defense. The question is—
Let me just ask one question as to sequence. Based on the affidavits, it looks like on March 30th, 2011 was the original proposal. And then there was a discussion with Mr. Gunn, or at least the affidavit references a discussion with Mr. Gunn on April 8th, 2011. So about 9 days later. So is it based on the affidavits, is it your position that the settlement needed to be accepted before Mr. Gunn had further communications? Or if there were those communications, was there any response by the plaintiff saying, no, we just want to have a stay, and if you agree, you pay up to the policy limits?
Yes, Your Honor, absolutely. Both and something else too. First of all, the original state proposal was not 9 days earlier, it was 4 months earlier. It was in December of 2010. And the letters to and from Mr. Odom and Mr. Reynolds confirm that in the record. At page 3899 and around there of the record. So it's a 4-month window of time before the consent judgment issue even arose, where there was an opportunity to protect the insured by entering into this stay agreement. The issue of whether and then the court asked, okay, did we tell them, hey, all we wanted was the stay proposal? The answer to that, again, is yes. Both coverage counsel and plaintiff's tort counsel said immediately after this June 3rd rejection letter from State Farm, all you had to do was agree to the stay. And again, no one was mentioning consent judgment in any part of this. And it's our position, the reason the consent judgment was not mentioned in all but one of these letters is that it wasn't made a condition. That the original state proposal that had been open for 4 months before anyone mentioned the words consent judgment still was in effect. It had not been withdrawn. It had not been changed or amended to require the consent judgment. And it's our position that the trial court erred in determining a disputed fact issue on that and ignoring the letters and requiring counsel to file an affidavit instead of giving any weight to the contemporaneous letters. The issue of whether the stay proposal is a Cunningham agreement is an important issue. And in our case, the trial court basically found applying Cropolac, which this court did apply Cropolac in the Marcuson case, which is a change in the law. It's the first court to have adopted Cropolac in a state court case. The trial court held in an order drafted entirely by State Farm, number one, you required a consent judgment. Number two, even if you didn't require a consent judgment, the state proposal was really a Cunningham agreement. And I want to talk about why the state proposal was not a Cunningham agreement. The state proposal did not require an excess judgment or the functional equivalent. It did not ripen the bad faith case prematurely. It did not require to waive or forfeit any condition precedent. And what Cropolac held and what Marcuson in this court adopted is that there's no duty to agree to an excess judgment or the functional equivalent.
Ms. Gunn, you have about 15 seconds to conclude.
I would love 15 minutes for all these issues, Your Honor. So briefly on the public policy issue, this is not a claim seeking indemnity for Ms. Game. This is a claim for damages caused by the breach of the fiduciary duty during the time of defense. And it is similar to the Mandelbaum case by this court, rejecting the idea that you can escape your liability for causing damages by arguing that the judgment against the plaintiff would not have been covered by their insurance. If the court doesn't have any further questions, we would ask that you reverse the summary judgment in favor of State Farm and reject the prosecutor.
Very good. Thank you very much, Mr. Levitsky. I don't see you waving your hand that you need to respond to something, so I'm assuming you don't. And same thing for Ms. Ryder. I don't think you waved anything saying help me. So absent somebody saying we need to say something, we will conclude. All right, nobody's saying anything, so we will leave it at that. Thank you all. Well presented.